Good morning. Welcome you all in this panel. My name is Cheol-Kyu Hwang, chair of this panel, vice president of World Jurist Association, immediate past president of International Association of Prosecutors, IAP, and I'm a former high chief prosecutor in Korea. Now I am an attorney at law and a chair professor in Korea. I'd like to thank you all for taking the time out of your busy schedule. Today, our panel will discuss the topic, international arbitration and technology. Recently, the measures for digitalization of arbitral proceedings aimed at achieving speediness, efficiency, and economic feasibility in arbitral procedures have been actively discussed in a global context. This is considered as part of the efforts for each state and arbitration institution to host international arbitration cases by providing high quality and reliable arbitration services, which is an operational matter for an arbitrational institute. Especially in response to COVID-19, the International Chamber of Commerce Arbitration and ADR Commission established a working group to update the 2017 edition of its report on the information technology, which identifies issues to be considered when using digital solutions and processes in conducting arbitration proceedings. The report indicates the use of technology tools in international arbitration will increase in the future, increasing a break from old practices, such as hard copy filings, and the increased use of other, currently underused forms of technology, such as e-briefs with hyperlink exhibits. The report, however, does not endorse any specific developer, product, or service as technological developments continue to evolve rapidly, and the different stakeholders have their own unique needs and circumstances, making it difficult to recommend a single technology that works in every case. Rather, the report is meant to provide general information about tools and services that exist so that parties and tribunals can make informed decisions while investigating the marketplace for themselves. Under these circumstances, during COVID-19 period, Korean Commercial Arbitration Board established a digitalized International Dispute Resolution Center, IDRC, in Seoul. The center's facilities have been very popular, not only for Koreans, but also international arbitration community, due to the advanced virtual hearing system and other cutting-edge equipments. In addition, as you are well aware, lots of global law firms are making every effort to invest to enhance the effectiveness and efficiency of the international arbitration by utilizing artificial intelligence. By taking today's opportunity, I hope we will be able to harvest fruitful outcome for the bright future of international arbitration supported by technology. Now, we will proceed to the panel presentation and discussion. Before moving to the panel presentation, I will let you know the panel timings. Total panel is 1 hour, 30 minutes. And each panelist will have a maximum of 7 minutes for their main speech. The remaining time will be for discussion among panelists and for the Q&A session with the public and the press. We encourage relaxed, easy speeches so our messages clearly reach general population as well, aiming at positively impact society. I will briefly introduce each panelist when he or she has the turn to make presentation. At first, according to the email list, I will introduce the first speaker of our panel is Mr. Miss Elisa Figueiredo from Brazil. She is a partner at Fernandes, Figueiredo, Françoso, and Petros. Miss Elisa Figueiredo, you have the floor.
Thank you. Good morning. It's a pleasure to be here with panelists from many different countries and backgrounds discussing such international arbitration and technology. Today, I would like to talk a little bit about arbitration in Brazil and the impacts of technology on international arbitration also. As I've previously discussed with my colleagues, technology is pretty much the same everywhere, some of whom will talk here about the use of AI in international arbitration. Therefore, I'll try to focus on the Brazilian scenario and highlight only two examples of technology used in Brazil to avoid any overlap with other panelists. As you all know, sometimes to solve a dispute or to fulfill an arbitration clause, the parties start before a mediation process, and in case they do not reach an agreement, then an arbitration takes place. In some cases, mediation starts even during the arbitration process. The main point here is that technology is being used on both procedures. In Brazil, as well as all around the world, its use increases every day. There's a recent study in Brazil, coordinated by FGV, one of the best law schools in Brazil, using data from the 7 biggest mediation and arbitration chambers in Brazil, including ICC in Brazil, for the past 10 years, from 2002 to 2022. The study found an increase in mediation proceedings in Brazil during such periods, experiencing a peak during COVID years. Another interesting finding, and what relates to this panel, is that the practice of the remote and hybrid mediation, even post-COVID, has been maintained in levels even higher than expected. The biggest arbitration chamber in Brazil, CCBC, it's the Canadian and Brazilian Chamber of Commerce, published a latest report a couple of weeks ago with the 2022 arbitration and mediation data. It concluded that the number of remote hearings exceeded the number of in-person or hybrid hearings, both in mediation and arbitration proceedings. In fact, what is interesting, almost 82% of the arbitration hearings and 94% of the mediation meetings were held remotely, confirming the previously mentioned study. There is, in fact, a clear and direct correlation between the use of technology and the steep increase of virtual proceedings. There is no turning back, and the parties must be prepared for that. With improved technology allowing for a more reliable and secure platforms of video conference and the effectiveness and convenience of virtual hearings experienced during COVID, parties, lawyers, arbitrators are now more than ever heavily relying on online communication. I'll just highlight two advantages of the remote proceeding that I'm sure you all know. Cost savings, of course, for involved parties, and shorter proceedings. As you know, international arbitration, some of the parties are from different countries. No more incur in logistic costs. Secondly, not only the remote or hybrid hearings, and more important, they shorten this proceedings timeline due to the increased flexibility in scheduled hearings and meetings. Of course, time is money. Arbitrators, party, and experts will likely be from different countries in international arbitration. There is no longer prejudicial to the proceedings. There are still issues to be considered, such as applicable law and language, for which technology also helps and improves, but I do not have enough time to discuss this, and maybe our colleagues will do. In addition, another interesting conclusion of such study and report relate to disagreement of the parties on the appointment of arbitrators and mediators, and also increasing in the arbitrator challenges, especially due to conflict of interest. You are all aware of the great importance of choosing the right mediator, especially the right arbitrator, to be succeeded in the proceeding. Therefore, deep background checks and independent due diligence are mandatory, at least in our office, in order to choose an arbitrator, not only for compliance purposes, but also to ensure that the chosen arbitration is the one that best fits in the case in terms of experience, etc. Nowadays, artificial intelligence and technology are vital tools for such important tasks to ascertain the independence and impartiality of arbitrators. These tools are also used to anticipate any potential conflict of interest and avoid the challenges of an arbitrator. The information gathered by those tools is more complete, and the research is faster and cheaper than it used to be before the increase of technology. Again, time saved is money saved. In Brazil, the arbitrator challenges are unfortunately increasing both before arbitrator chambers itself and the courts. Usually these cases are handled, as you all know, with special committees created to rule such challenges. And very often, not only the committee dismiss these challenges, but also many arbitrators that are challenged, they resign. And those dismisses lead to an increasing number of lawsuits before courts in Brazil, questioning the impartiality and independence of the arbitrators and about the disclosure obligations. The latest case in Brazil at the federal court related to the disclosure obligations, whereby the enforcement of the arbitration award was suspended just last week by the federal judge until there is a decision on the merit on such conflict of interest disclosure obligation of one arbiter, which may lead, unfortunately, to the annulment of the arbitration award. A thorough background check and independent research to the appointed arbitrator, with the use of vast technology available right now, then at the very beginning of the arbitration could have avoided the challenge raised after the arbitration award was issued. It can also prevent the use of impartial arbitration, which can lead to the annulment of the award, thereby saving additional expenditure, time, and money. Well, there are plenty of other examples on how technology and artificial intelligence may be used for domestic and international arbitration, including more interesting ones than the ones I've already said. But I'll leave these to my colleagues here in this panel. But before ending, I would like to mention that while the use of technology in arbitrations has many advantages, we still must consider the potential challenges that it brings to us. Here are some food for thought. Is the remote hearing the best alternative? I have mentioned some of its advantages, but do we lose vital information gathered from body language and face-to-face meetings? Are the existing techniques and technologies enough to replace an in-person hearing of a witness? That's one point. Another one, are we ready for arbitration award to be granted by artificial intelligence? Is it permitted by law? In Brazil, there are many discussions saying that our arbitration law does not allow this kind of ruling. Last but not least, on arbitration, the parties' autonomy to set the rules applicable to the proceeding makes it easier to introduce technological resources. Such flexibility, though, is not absolute, being limited to the principle of laws, to the rule of law that we are discussing a lot in this Congress. So, at what point would technology impair or hinder such principles? Well, I leave you with those questions to consider, and I look forward to hearing from other panelists. Thank you so much.
Thank you, Elisa. Elisa talk about the scenario of arbitration, international arbitration in Brazil. She tried to focus more on Brazilian reality. I'm sorry I skipped her biography. I'd better skip the all biographies before introduce. I will introduce you because I'm sorry I skipped a brief CV of the Elisa Figueiredo, so I will let you know her a brief CV, even though it was a little late. She's Elisa Figueiredo is a founding partner at the Fernandes, Figueiredo, Françoso, and Petros law firm in São Paulo, Brazil, responsible for the area of private law with focus on strategic civil litigation and arbitration, master in international law and international relations at Universidad Complutense de Madrid, specialization in litigation and contracts, and executive LLM at the CEU Law School in São Paulo. Now I would like to move on to the next speaker, Mr. Guillermo Cáez from Colombia. Guillermo Cáez is he's a dispute resolution partner of CMM Abogados, and president of Center for Procedural Law Studies, CEDEP, member of the arbitrated roster of the Chamber of Commerce of Bogota, and Medellin and Cali, as well as a columnist for the prestigious economic newspaper La República of Colombia. Mr. Guillermo Cáez, you have the floor.
Thank you to the chair, to the organization for the invitation. I'm trying to speak about two topics related to the blockchain and smart contracts and the utility in the international arbitration. One of the main purposes behind the creation to the blockchain for Bitcoin was to establish a peer-to-peer network and eliminate the need of intermediaries. However, this objective does not align with a dispute resolution mechanism like arbitration. We were one of the actions in that peer-to-peer relation between the parties is not effective and is not intentionally seek involvement of an intermediary, that means arbitrator, to settle the dispute. For this reason, the use of centralized entity to control to the blockchain used for the dispute resolution is currently the best solution available. The traditional arbitration institutes currently handle the logistical aspects and process through a storage service like Box, where parties can upload their motions, evidence, and they can exchange information. This mechanism would not work in a public network we use, where anyone could be practiced and add new elements. Therefore, in a blockchain technology, if blockchain technology is to be utilized to leverage its automation and private network management by the entity handling the dispute, such an arbitration institution will need to be used. This way, the entity operates the blockchain will have the ability to remove, edit, and eliminate entries to the blockchains and remove users. However, the parties should also consider that be centralized control of the blockchain in an entity, the cybersecurity that the principal characteristic of the centralization in the Bitcoin and the diversification at node network across multiple nodes may be dismissed. One aspect to consider about the mechanism is that the one intrinsic characteristic of the blockchain in the use pseudonymous, or otherwise the parties can use the original names. For an arbitral awards execution to be recognized by the states, the names of the contracting parties and the dispute must be known, even kept confidential. At this point, I believe that the blockchain to be useful for the arbitration, the parties cannot remain anonymous. The parties must be identified for the dispute to be effective between them. This way, the parties can plan their legal strategies regarding aspects such as intermediate measures, enforcement, and annulment depending on the counterparty location. Another issue with the unchanged dispute resolution is the tribunal decision will be limited to the consequence agreed upon the smart contract. To address this challenge, the parties could be agreed in the arbitration agreement that the tribunal will resolve the dispute according to the terms the smart contract may also award remedies not contained with the blockchain through an arbitration award. Such a decision will make the dispute hybrid, partly within the change and partly out of it. Another potential obstacle with the enforcement of our issue of the blockchain is that in certain companies offering the blockchain dispute resolutions, the adjudicators, that means the arbitros, are anonymous. That is, the adjudicator is not the same the original award or a copy. This circumstance will be create a recognition and enforcement problem that will be discussion in the next part. Since smart contracts are self-executing when the dispute arises between the parties and thus automatically generate and the terms in not accordance with the applicable law, this will cause issues in nullification or no performance. The contracts code provides for arbitration to consequence automatically upon the occurrence of the specific events. One party may not participate in the arbitration or may to be notified. A similar situation occurred in off-change dispute. In case before the Court of Appeals of Amsterdam, the case was based in a vehicle loan agreement. The terms and conditions of the platform through which the loan was made containing an arbitration clause resolved through arbitration in California before sole arbitration. However, the clause stated the arbitration will commence automatically in one of the parties failed to make the loan payment after 90 days. A recent proposal by the company Datarella is a combined smart contract with arbitration, when the parties agree to have the smart contract to regulate their legal relations and choose to resolve their disputes through arbitration. The process will work as follows. While the economic relationship to the parties is ongoing, the smart contract continues to operate. If a dispute arises, one of the parties can activate the code that suspends the execution of the smart contract while the dispute is referred or arbitration. The arbitration takes place outside the blockchain. Once of the arbitration reach a decision, they input a command in the smart contract to terminate and trigger the legal consequence determined and previously specified in the smart contract. This proposal seems to combine the benefits of automatic and smart contract with the traditional arbitration, which can work effectively for the economic and legal perspective. Dispute resolution through basic arbitration was a raised question because it's not efficient and realistic for the parties to keep large amount of money on a blockchain where it's not dispute between them. Other criticisms or change arbitration are based in the fact that the process before online service providers parties online submit initial documentation without going through the document production stage, and the dispute is not resolved with consider the precedents, the recent precedents.
Thank you. Thank you, Guillermo. he talked about blockchain, smart contracts, challenges, and applicability in international arbitration. Now, move on to the next speaker, Mr. David Zaslowsky. David Zaslowsky is partner in Berkman McKenzie's New York office. He has practiced international arbitration for almost 40 years, both inside and outside the U.S. Under the rules of various arbitral institutions, as well as ad hoc arbitrations, including the ICC, AAA, HKIAC, LCIA, ICDR, NASD, and the Iran-US Claims Tribunal. David has a degree in computer science and, as a result, has worked on numerous technical-related disputes. He is on the board of New York International Arbitration Center, and he is a founding member of International Arbitration Club of New York. Dave acts as both counsel and the arbitrator. And he is also chair of the governance committee of New York Arbitration Center, member CITIBA Task Force on Digital Technology, and CITIBA International Commercial Dispute Committee. Mr. David Zaslowsky, you have the floor.
Thank you. So if we're talking about technology and arbitration these days, somebody has to talk about AI, and so I will be that somebody. And in the 7 minutes I have allotted, I'm going to try very quickly to touch on 5 areas where there's AI really overlaps with IA, with international arbitration. Let me start with an area of AI that actually is being used, right? Predictive coding, or known to others as technology-assisted review, TAR. And from 50,000 feet, or from 100,000 feet maybe, right? The way TAR works is it starts by you train the software with a set of documents, with a set of data that lawyers actually review, and they determine whether particular documents are relevant, have to be produced or not. And through some type of iterative training, the ultimate goal is that the software it will be the one that goes through the thousands, tens of thousands, and in some cases millions of documents, and it is the software that makes the decision whether a particular document should be produced. And that is way oversimplified, but that is an example of artificial intelligence that is currently being used. And going back to 2012, the United States courts have already endorsed this type of practice. Now, when you move that to international arbitration, so many arbitrators outside the United States who are not at all used to discovery, much less this type of discovery, there's a learning curve for them to be able to use this. But it is a tool that's actually being used. So that's number one. Number two is using AI to do research. And there is now a famous, infamous, very recent case in the United States. I don't know how many people outside the United States know about it, but of a lawyer who used AI, used ChatGPT, to write his brief, and the brief included cases that did not exist. ChatGPT made up the cases. This brief was submitted to the court, raised the whole brouhaha. The lawyer was ultimately sanctioned, but it led to a number of courts in the United States issuing orders saying you cannot use ChatGPT or generative AI in general, or if you use it, you have to disclose it to the court. And so, should we use that in arbitration? Should arbitrators issue similar types of orders? And without taking a position one way or another, let me at least posit the case that arbitrators should not be touching this at all, right? What happened in this New York case was simply an example of really bad lawyering. Right? You should never submit a case in a brief that you have not read, that you have not reviewed. And so, I don't think we should be setting rules in arbitration, or perhaps in courts for that matter, that go to this lowest common denominator. Right? And now also, how different is this than using ChatGPT? How different is that from me walking down the hall into my partner's office and discussing the case with them? And walking out with that partner giving me some ideas that I had not thought about, or told me some cases that I have not thought about. Nobody would ever say that I need to disclose to the court, to the arbitrators, that I spoke to these partners. So how different is that from using ChatGPT to give you a case, or again, any type of generative AI? So do you really need that kind of rule? Because is it really that different from what we all do just by talking to our colleagues? Number three, using AI to select arbitrators, right? So AI systems, you can feed in the particular type of dispute and information about types of disputes that other arbitrators have determined that they've ruled on in the past, and come up with a good idea of who should be an arbitrator. Essentially, you are substituting a data-driven process for what until now is much more of a human intuitive process. So that's area number 3. Area number 4 is using AI to write awards, right? Especially in investor state awards, right? We see these decisions that you have dozens and dozens of pages at the beginning of these awards that really do nothing more than recap the procedural history of the case, all the pleadings filed in the case. And I'm pretty sure right now there already exists private AI products where you could feed all of this in, and the AI can give you at least a very good first draft of these procedural history parts of the award. Is that okay? Are there any rules of law issue saying that, no, a person needs to actually draft the award? Now, but why shouldn't AI be doing that? Now, let me also put one caveat on that. Don't take all this stuff and feed it into a ChatGPT or a Bard or any other of these publicly available AI products. I mean, that raises issues of confidentiality and privilege. Anything you submit that you feed into these types of AI products, it's all kept, it's actually used to continue to teach the AI. So you have to avoid confidentiality issues there. But if there are private AI products, and they do exist, why can't you do that to write the first part of the award? And then the last issue I want to talk about, and again, this is something that Elisa touched on, but what probably some see as the holy grail for AI. Let AI be the decision maker. Can AI be the decision maker? Does it raise issues of rules of a violation of the rule of law? I think that it probably will happen, and according to some articles that you read, it already is happening in certain areas, where with relatively small cases, it is AI that is making the decisions. And I think that's probably a good idea in certain places where you have very congested court dockets and you have small cases. And if a person has to get involved and make the decision, it could take years and years before you're finally going to get a decision. And I don't think measuring the efficacy of this is the AI getting it 100% right. I don't think judges get it 100% right and defining what right is. So I think the test should be whether it is improving the justice system in terms of getting reliable results in cases, especially where otherwise congested dockets would take years for these cases to be decided. In larger cases, complicated cases, I'm not so sure that is on the horizon. One of the issues that's always raised with AI, and all the AI companies admit it, is that there are biases in the way the AI is trained, and that causes biases in the output you're going to get. And so you're going to have biases in the decision-making. Also, judging by arbitrators or by courts, it does require, I think, some level of empathy. And at least so far, I don't think empathy has been built into the AI models. AI is going to be built on huge databases of existing decisions. And to the extent that those decisions have errors in them, those errors are going to be perpetuated in AI-based decisions. So that's another problem. I think the last point to make is that AI doesn't have the ability, at least yet, to adapt to changing social mores. And so if we use an example in the United States, right, under Plessy v. Ferguson, the United States Supreme Court decided in 1896 the concept of separate but equal, that's okay. And yet, 58 years later, in Brown versus Board of Education in 1954, a unanimous Supreme Court said, no, separate but equal is unconstitutional. That was based in large part, it wasn't a change of law, it was a change in large part of what was happening in the country and social mores. AI, how is AI going to do that? So this issue of AI making decisions, especially if you're thinking about the rule of law, it implicates lots of things. The fact is AI is moving so fast that if we had this conversation a year from now, it's probably very different from what I just talked about over the past few minutes. But I think one thing that is undeniable is that AI is already in the world of international arbitration and will continue to grow in the world of international arbitration.
Thank you, David Zaslowsky. Very interesting talk about the use of artificial intelligence in arbitration now and in the future. Issues such as predictive coding, early case analysis, selection of arbitrators, award drafting, AI replacing arbitrators. Now, let's move on to next speaker, Mr. Luiz Claudio Allemand from Brazil. He is a partner at Allemand, Consultoria, the Advocacia, Empresarial, and then also he's an arbitration. He's working at the Arbitration Chamber of the Federation of the Industries of Espírito Santo. Mr. Luiz, you have the floor.
Thank you so much. Good morning. I would like to greet the member of this panel, and special Mr. Hwang, and thank to organization to invite me. I love ethics, study ethics. I love to study law. I love to study technologies. And then when we put together, I discovered a big problem. And I will try to show in this in 7 minutes. I'm currently working on a research line on ethics and technology. But in this presentation, I will approach the topic of ethics and artificial intelligence and international arbitration. We are living an extremely important moment in the human history, so-called knowledge era, with a design speed of disruptive technology that arrive and disappear, being surpassed by other technologies at a pace that has never been reported in our history. A cultural shift must occur even for the most skeptical, as we do not fight against machines, but with machines. Technology helps us be more efficient, but we need to observe rules of governance, compliance, integrity, and ethics because technologies grow exponentially while ethics does not keep pace. With the pandemic, arbitration chambers, especially international ones, had to adapt it and incorporate new technologies, such as video conference hearings. However, other areas of international arbitration can benefit from artificial intelligence, such as legal research and document review, predictive analysis, evaluation of produced evidence, voice recognition, transcription, interpretation, and translation. Nevertheless, the use of artificial intelligence in the selection of arbitrators and the drafting of arbitral decisions requires risk analysis and respect for integrity rules. Artificial intelligence in law and arbitration is already present itself in the following ways. First, any human activity that involves repetitive and low complexity tasks has already been achieved. And second, algorithms work with more details in operation of databases in a big data technology allow for faster data storage and analysis. And third, with a simple cognition, algorithms can extract reports, generate documents, contracts, and legal studies. Research and development in AI is in the legal field are trying because open code sees a cost that is paid over time. Labor is a continual cost, close code. However, when it comes to technological development, it is necessary to observe integrity rules. The developers of these technologies do not concern themselves with sociology, philosophy, and ethics, precisely the pillars that give birth to law. Regulation of artificial intelligence is necessary, especially when algorithms may be designed arbitral procedures. In 2017, at Asilomar, a small city near Monterey, the Future of Life Institute in the United States brought together leading researchers, scientists, and politicians to define the best way to ensure the safe use of artificial intelligence. In the field of law, in the area of ethics and values, Directive number 8, or Principle number 8, draws attention, which deals with judicial transparency, open codes, and involvement of an autonomous system in a judicial decision-making must provide a satisfactory and explanation by a competent human authority. Close quote. In a conclusion, there is a consensus that responsibility, transparency, incorruptibility should be observed in the development of algorithms intended to replace human judgment, whether in a court of law or in arbitration. In the digital world, only those who build a credibility and reputation will survive, which can only be achieved with ethics in business. In the word of Peter Drucker, open codes, demand of yourself to reject behaviors that you do not respect in others, so that you can look yourself in the mirror in the morning. But I try to, I like to use the words of Jamie Bartlett, a British journalist, author of the book, The People vs. Tech, How the Internet is Killing Democracy and How We Save It. In an interview, the author stated the taking care of our online behaviors is more important than vote. Open codes. The first thing we need to understand is why we were so naive in the beginning. Close quote. Thank you so much.
Thank you very much for your meaningful presentation. And let's move on to the next speaker, Mr. James Black. James Black is the Vice President of World Jurist Association on behalf of American continent, and partner and General Counsel Falcon, Rappaport, and Berkman. And also is an adjunct professor of the Hofstra University School of Law. Mr. James Black, we have the floor.
Thank you very much, Mr. Hwang. Good afternoon, everybody. As Hwang mentioned, I am a partner at Falcon, Rappaport, and Berkman, and a professor at Hofstra, both of which are sponsors of the Congress. So on their behalf, I want to again welcome everyone to this great event, and I'm very, very pleased and honored to be serving on a panel with these very seminal individuals. So thank you all very much. As both a practitioner, professor in data privacy and in ethics and compliance, those are going to be sort of the focuses of my, well, actually let me turn on my timer so that I stay in the time. There we go. My short presentation. But before we get there, I just want to sort of back up and say, what are we talking about when we're talking about AI? A lot of this is actually things that we're already using. We all have video conferencing. I mean, I just looked at my phone before. Just on my phone, I've got Zoom, GoToMeeting, Teams, WebEx, and there are probably 6 or 7 other ones. But for those of us, shall we say, of a certain age, we have to make sure that we know how to use it. Just like that story of the poor lawyer who cited a case that didn't exist, there was a somewhat funnier and less fatal example of a lawyer who had to explain to a judge that he was, in fact, not the Cheshire Cat, because that was the face that came up on the video. But again, for some of us, when we're using all this technology, admittedly, we do feel sometimes like we are with Lewis Carroll's Through the Looking Glass in a New Backwards World. Again, also, of course, we have online case management. Most of us have used Dropbox and understand it. The concept that now will be e-filing in arbitrations, just like we've been doing in court for many years in most countries. As David mentioned, the fact that we're using AI-powered tools to scan and do research, although again, he makes an excellent point. Are they a tool, or are they starting to do some of the analysis and decision-making for us, which on very many levels actually creates to be greater problems? And then, of course, there's also the issue of the use of blockchain. Before preparing for this panel, I thought blockchain was used to buy cryptocurrency and these funny NFT pictures of monkeys. But it's more than that, apparently. And we can use it to create an unchangeable, unalterable record, unless it's hacked, which I'll talk about in a moment. And more importantly, can we tell when it's hacked? Speaking of hacking real quickly, I do some cybersecurity work in my practice, and in talking to an expert on that a number of years ago, because you always hear about when things, hacking occurs, and I said, well, how is it that a hacking occurred 2 years ago, but how come we're only finding out about it now? And the cybersecurity expert said, you're asking the wrong question. Why are we finally finding out about it? That it's much more likely that you're not going to find out about it for a very, very long time. So imagine for a moment a world where we have a record that's created and supposedly unchangeable that was hacked, and the arbitration record has been changed by a hacker. Again, part of this world that we're in gets a little scary. Moving on real quickly, some of the advantages, of course, is that everything moves quickly. Back in my day, we would talk about we're doing litigation or documents of, how many trees did we kill? As we sit here in the shadow of the United Nations and the concept of climate change we worry about, by doing this all on technology and all electronically, we're not creating paper, we're not printing things, we're saving things. And I think finally, many of the lawyers that I used to work with who printed their emails to read them have finally reached retirement age, so we're actually not printing our emails, we're actually are actually reading. So again, some of those, but many challenges that we are, again, we're weighing the benefits of technology against security risks. One thing I think that we should think about also is we continually hear what we call the North-South divide, the divide between the developed and developing countries. Is AI creating just another example of that, where if you are from a so-called developed country, you have the ability to use these tools. But if you're from a developing country and you don't, are you automatically in international arbitration, put it in an almost impossible disadvantage? So are we moving too quickly on that? And are we not really giving thought to the unfairness of some of these digital tools if they are not truly available throughout the world? And again, I just wanted to touch real quickly on something that also that David mentioned, is software making decisions for us, as opposed to just being a tool. Is it a tool or a decision maker? For those who know me well, they know that it's unlikely for me to give a talk without referencing a movie or Disney or a show. And I would think everyone, if you haven't seen, think of the movie WALL-E, where all human beings are sent into space and they all become soft and fat and they're not using their bodies anymore. Is that what's going to happen with some of our minds? When is it are we going to replace human analysis with this high-end technology? And I think that's a danger that we should be very careful that we're not using. And David made the point that, AI is impersonal. And that's right. Many of the decision-making of courts, of arbitrators, of mediators, is that so-called human touch. And if we think we don't know what it looks like, for any of the Star Trek fans in the room, you've met AI. His name was the character of Data. That's exactly what AI is in tangible form. And is that really who we want to be our arbitrators? Real quickly, the idea of data protection, of course. So we are exchanging these documents, which is very efficient, and it's going cross-border. But there are so many and not entirely consistent data privacy regulations. GDPR, CPRA in California, New York, Virginia, in other countries, Brazil, China, India, they all have rules, but they're all not consistent. So when we're exchanging data and documents, which rules are we complying with? And more importantly, which countries is it going through? The concept of encryption. But what encryption level is enough? Is 2048 enough? Is 4096 enough? Do we need new levels of encryption? Because when we think about one of those challenges is we're all, in arbitration and in mediation, we're all signing confidentiality agreements, NDAs. But does the cloud really actually honor that? And if we're storing data in the cloud, we get to the end of an arbitration and we say we're going to dispose of everything. To what way do we really know that everything in the cloud is being destroyed? We no longer use servers for the most part. We use the cloud. So how are we creating technology that causes us to almost make it impossible for us to comply with the agreements that we were signing every day thinking it was an easy thing to sign. But as technology made some of those things now really, really impossible. And again, as I mentioned before, from an ethical standpoint, are we creating inherent biases to certain countries and certain companies? It already was that, the big companies can hire big law and have the advantage. But now can bigger companies and certain other companies use, and use big technology against the people who are in small technology, and how fair is that? The last point I would just make real quickly is about training. And that if we're going to use these tools, everybody needs to be trained on them. In fact, question, should we probably train first and then start using them? Because, we can all joke about the poor lawyer who looks like the Cheshire Cat, but now move that into the real document creation, document discovery, arbitral decisions, research. And are we getting ahead of ourselves in creating situations where we can't control the technology, and the technology is not as much of a helpful tool as it is an ethical and technological and perhaps ethnic bias against people. So with that, I think my time is up, and I thank you all.
Thank you, Jim, for your excellent presentation regarding heightened need for data privacy and security regimes as arbitrations become almost completely digital. The depersonalization of the arbitration because of the migration to the remote arbitrations and mediators. And last but not least, he also emphasized on the training. And then let's move on to the next speaker, Ms. Xinghai Shi from China. Professor Xinghai Shi is a professor of School of Law, Lemning University of China. Her main specialty focuses on international business and economic law, particularly cross-border insolvency, trade in services with abundant publications. In addition to teaching for 25 years, she also practiced arbitration under the rules of various arbitral institutions, including the ICC, HKIAC, CIE, TAC, BAC, retained as an expert witness in high-profile international litigation and arbitration as well. Xia holds an AB, LLB, and a PhD from Wuhan University, and LLM and SJD degree from Yale Law School. She was admitted into New York in 2011 and the National Bar of China in 2001. Ms. Professor Xinghai Shi, you have the floor.
Thank you so much, Chair. Ladies and gentlemen, good afternoon. It's my great pleasure seeing all here. It's also my privilege, talking about this subject with a very distinguished panel. I think this panel is fascinating. We can approach the theme of this panel from many aspects, but recognizing the time is very limited. I would talk about 3 points. I try to introduce the latest developments in China about the data protection law or legal regime, and thinking about the possible or potential challenges dealing with this kind of issue in international arbitration. So first, briefly about we call the so-called 3 pillars about data protection law in China. In 2016, cybersecurity law was introduced, and in 2021, data security law and personal information protection law were also introduced as well. So together, it's DSL, CSL, and PIPL. So these 3 pillars about legal regime in China with respect to data protection. Someone viewed this legal regime as more restrictive than GDPR. But I'm trying to thinking about what kind of impact of this legal regime on international arbitration. Basically, depending on the volume, the nature of the data, and whether a so-called critical information structure operator or so-called CIO is involved, the exporting entity face very many potential legal options. I will identify three. First one is, basically this, you will see it kind of familiar if you are familiar with GDPR. It's a so-called standard contractual clause, signing a contractual clause with the overseas data recipient. The second option is to obtain a personal information protection certification from a CAC. I call CAC is China, is the Cyber Administration of China. CAC recognized the professional institution, or you can understand it as a institution designated by CAC. The third option is to pass a security assessment by the CAC itself. So looking this all together, you can say exporting entity needs to either obtain the consent of the data subjects when necessary. This is kind of so-called sensitive personal information, and provide a detailed notification to data subjects, or inter alia the name, the contact information of the overseas recipient, as well as the purpose and the method of the data processing. So specifically on the impact of this legal regime on international arbitration, the main legal issue here is how to interpret the Article 36 of Data Security Law, DSL 36, and 41 of PIPL, which basically contains special restriction on data exportation from China to so-called foreign judicial or law enforcement authorities or organs or bodies. So how to interpret foreign judicial or law enforcement organization, arbitration institution, or even arbitral tribunal are also included in this phrase or not. So, however, so far, Chinese, the government agency has not published any clear guidance on their application in the arbitration context. But according to some unofficial inquiry with the Ministry of Justice, MOJ, data exportation to arbitral tribunal or institutions requires approval by the MOJ, which, this process, if you do it, it may take at least 1 month, or at least you need to pass the so-called security assessment I just mentioned by the CAC. So the conflicts, as you can see, with respect to data protection law issues are often materialized in the disclosure process in arbitration. So in recent years, we have been seeing a trend, which is that some Chinese parties are relying on this kind of data protection laws to resist a counterparty's production requests, or to substantially, this can substantially delay the arbitration proceeding by citing a need to conduct a self-assessment or to obtain approval from the relevant Chinese government agencies. It has been noted from Hong Kong International Arbitration court, in which I also serve as a arbitrator. Since several cases in which the legislative gaps in data security law, Article 36, and PIPL, Article 41, led to some challenges in arbitral proceedings. Parties have raised different interpretation of these two articles before tribunals, occasionally even adopting, so-called double standards to produce documents in their favor, but decline, the other production requests, citing, they need to comply with data protection, legal regimes in China. So these issues were even further complicated by the lack of consistency right now in China, Chinese authorities' approach towards data exploitation in international arbitration. In some arbitrators' experience, as I can say, because I was involved in some, this kind of symposium. Not from my personal experience yet. You can see in some cases, MOG, Ministry of Justice, they said, okay, this kind of approval is needed, in advance. But it was also you can see in some other cases, MOG concluded, such approval was not necessary. So it was mentioned that in some arbitrations, the Chinese party conducted a so-called self-assessment and submitted an approval request for the data exploitation to different government agencies in China. But in response, some of the authorities, they provided feedback, but orally, on the circumstances in which, submission in a arbitration could be transferred, the data could be transferred across the border, whereas others declined to review the parties' request on the basis that arbitration affairs were outside the scope of their responsibilities. This is not from MOG, but from different, like CAC, some other agencies. So basically, given the present uncertainties, it proposed that where a Chinese party cited a Chinese data protection legal regime, but was unable or unwilling to provide disclosure in arbitration, potential solution available to a tribunal include like drawing adverse inference or in imposing cost consequences on the non-disclosing party pursuant to Article 9 of the IBA rules on the taking of evidence in international arbitration, or releasing both parties from document production obligation in order to level the playing field. However, dealing with this kind of issue at the disclosure stage would inevitably result in delays to the proceeding for the parties and the tribunals, they need to consider data protection issues in advance to minimize delays in the arbitration process. In conclusion, I just, time limitation, because of time limitation, I just recall 3 pillars of legal regime with respect to data protection. They are still very new, still very even, the last 2 were introduced in 2021. That's partly can explain why, Chinese government agencies, there is inconsistency in terms of implementing these rules in the context of international arbitration. But either you serve as a counsel or you serve as a arbitrator, At least I think, for the arbitration concerning Chinese parties, these kind of issues, as I suggest, you need to consider this kind of issue, in advance in order to promote the smooth conduction of international arbitration proceedings. And also, I think this can potentially help China regulatory agencies with developing a more consistent approach to dealing with data protection issues in international arbitration with respect reference to the best practice in this area, including ICA, IBA, roadmap, and the protocol to data protection in international arbitration. I think I will stop here. I'm willing to, have a Q&A session. Thank you so much.
Thank you, Professor Xi. Professor Xi talked about the impact of technology on international arbitration from the perspective of data flow. According to Professor Xi, China has been put several data regulation laws into place which may affect international arbitration concerning Chinese parties or arbitral tribunals. Now, I would like to introduce our last speaker, Mr. Carlos Francisco Molina del Pozo from Spain. He is the director of Center for European Studies of University of Alcalá de Henares. He is also president of Euro-Latin American Institute of Integration Studies. Mr. Carlos Francisco Molina del Pozo, you have the floor.
Muchas gracias, señor presidente. Voy a hablar en español. Lo siento.
Okay.
Muchas gracias a la organización por la invitación y muchas gracias a ustedes por estar a estas horas ya también escuchando. Bueno, yo me había preparado una serie de puntos para tocar, pero efectivamente con el tiempo tasado es mejor ir al grano, como decimos en España. Ir al grano significa que una vez que somos conscientes de lo que es hoy día las nuevas tecnologías, cómo han incidido y cómo inciden en el arbitraje, de manera que son muy positivas porque le hacen que las decisiones se adopten mejor. Bueno, basta citar el informe hecho por la Cámara Internacional de Comercio hace unos años, pocos, el 22, para que nos demos cuenta de la importancia que tiene hoy día la aplicación de las nuevas tecnologías al ámbito del arbitraje internacional. Pero, sin embargo, ahí es donde yo quiero poner el dedo sobre la llaga. El arbitraje queda, como ustedes saben, excluido de los contratos públicos en el ámbito del derecho de la Unión Europea. Realmente quedan relegados a un segundo plano en lo que son los contratos con empresas extranjeras. Concretamente, tengo que poner de relieve la figura del Tribunal de Justicia de la Unión Europea. Para los comunitaristas, el Tribunal de Justicia de la Unión Europea es la institución chapó en el ámbito del derecho de la Unión Europea. Quiero decir que es la institución que ha creado el derecho de la Unión Europea, que ha creado los principios generales del derecho de la Unión Europea, que es el articulador del derecho de la Unión Europea. Y ese Tribunal de Justicia tiene una envergadura que es capaz, por lo que dicen los tratados, nada menos que de ser una especie de tribunal constitucional, no existiendo por encima de su veredicto nada. Y si hablamos de la interpretación que hacen con las sentencias de, por ejemplo, del año 2018, la República de Eslovaquia contra Allemand, pues encontramos que hay dos artículos, el 267 y el 344, dos artículos del Tratado de Funcionamiento de la Unión Europea que claramente se oponen a la utilización del arbitraje. Por tanto, ¿se puede decir que en el derecho de la Unión Europea no cabe el arbitraje? No, sí cabe el arbitraje en ciertos contratos, como he dicho, pero desde luego lo que sí está claro es que el papel del Tribunal de Justicia está por encima de cualquier interpretación arbitral que se pueda producir. El artículo 267 del Tratado de Funcionamiento de la Unión es el que establece la cuestión prejudicial. Solamente el Tribunal de Justicia es capaz de interpretar o de dar validez a las disposiciones del derecho de la Unión Europea, no solo a los tratados, a los artículos de los tratados, sino también a todo el derecho que emana de las instituciones de la Unión Europea. Por tanto, es un límite muy importante a la utilización del arbitraje dentro del ámbito del ordenamiento europeo, del ordenamiento comunitario. Si unimos al artículo 344, en que los Estados miembros se comprometen a no someter las controversias relativas a la interpretación y a la aplicación de los tratados a ningún procedimiento de solución de controversias distinto al que se prevé en los tratados, es decir, al contencioso comunitario, previamente al contencioso administrativo y luego al contencioso comunitario, tenemos que llegar a la conclusión de que existe por parte del Tribunal de Justicia una especie de límite a la utilización del arbitraje en el derecho comunitario. Y como ando con el tiempo muy justo, simplemente decirles que hace 10 días la Comisión Europea, el día 7 de julio, hace 10-11 días, la Comisión Europea ha dictado y ha propuesto que la Unión Europea, por ejemplo, en un ámbito en el que existe una cantidad enorme de litigiosidad arbitral, en el ámbito energético, pues la Comisión Europea ha sugerido ya a todos los Estados miembros que progresiva y ordenadamente se vayan retirando del Tratado de la Carta de la Energía. Por tanto, vemos que en los próximos años va a producirse pues, una baja, teniendo en cuenta que el arbitraje va hacia un 20%, calcula, un 20% de los litigios que se producen en el ámbito energético, pues ahí se va a ver cómo se retiran los estados del convenio, del tratado de la Carta de la Energía y, por tanto, habrán que buscarse otras fórmulas de solución de controversias en una materia que, como digo, ocupa una gran parte de los litigios en materia de arbitraje. Bueno, aquí me quedo. No tengo que decir que, por supuesto, el derecho de la Unión Europea prevalece sobre cualquier otro derecho, sea cual sea el orden jerárquico que ocupen las normas dispositivas en la jerarquía de las normas internas de cada Estado miembro. Por lo tanto, principio de primacía, que aunque ahora está puesto en entredicho por algún Estado como Polonia, nos regiríamos del tema, pero existe ahora mismo un procedimiento contra Polonia precisamente por no cumplir ese artículo, ese principio, esa característica del derecho comunitario. Y lo cierto es que esa primacía exige que se aplique el derecho de la Unión. y por tanto el arbitraje no va a estar en primera línea. Y lo digo, lo pongo sobre la mesa para la discusión, porque habrá que buscar alguna solución a este conflicto que se está orientando. Muchas gracias.
In order to help the other participants who are not familiar with the Spanish speaking, so I just asked Mr. Guillermo Cáez to make a main point of the speaker.
No, the main
Mr.
point was the Supreme Court, the European Union restrict the arbitration cases in related to the interpretation and application for the treaties between the member states. That is the main point. And for my colleague, is a big problem because the arbitration is not the first dispute resolutions rule. Is more the own courts and the Supreme Court in the European Union. That is the main point that was.
I would also add that his conclusion that the European Communion law prevails from each country's law.
Ah, yes.
So anytime there is a dispute, the ruling of the rules of the European Communion prevails and is higher than each country's rules.
Thank you. Thank you, Boss.
Thank you.
And then now, just before closing, we have just less than 10 minutes left. So, as I said, 5 minutes will be, the remaining 5 minutes will be for discussion among panelists and for the Q&A session with the participants and the press. I cannot find the press, but anyway, for 5 minutes, how about having discussion among panelists or together with the participants?
We'll go and see if anyone has a question.
Yes. Is there any, in the floor, if you have any question, please feel free to raise your hands and ask the panelists.
All clear.
Yeah. A very quick question to David.
Okay.
It's very interesting. You listed several kinds of use of technology in international arbitration. So, but I don't think I recognize you maybe the time limitation. You didn't talk about your views, particularly. I'm wondering. If you think at least some use are can be permissible, like for research, for even drafting like procedural history in arbitration award. As a user like decision maker, definitely only can be a reference, but not final. So I'm wondering if you can talk a little bit about your personal views.
I think it definitely can be used for research right now, but it's. If you equate it to, let's say, the product you would get from a first year or second year associate, and in some areas it will be like that, you just have to understand what are its limitations, right? The concept of hallucinations, it's real. I mean, it made up cases for it, and it's not. Well, and I remember discussing with my wife, and she said, "Well, what do you mean it made up cases?" Well, all that this technology is. This generative AI technology is, it predicts the next word. That's what you want. That's what the technology is. And so it's going word by word, and it doesn't know that it made up a case, all right? But it made up a case. So, but you as a lawyer, you have to understand the limitations and see what the cases tell you. It could give you ideas, and then you go with those ideas. So yes, it definitely can be used for research. It's going to get better. It definitely can be used for writing the like I said, the procedural procedural history of the case. Where it gets more difficult is, can it make decisions?
Yeah.
Right?
Yeah,
and I think one of the areas where it actually is, again, I've read about this. I don't know if it's actually true, but apparently there's a WeChat, some type of WeChat opt-in opt-in dispute resolution system within eChat where it is an AI that makes a decision. Again, I've read about it. I don't know if
No,
it's true.
I don't think
Maybe
it's
you don't
true.
know.
No.
But-
WeChat I use every day, even every minute. But WeChat doesn't have that function yet.
No, I don't
Maybe
think it's on your normal chatting app. But I think there's some part of it. Again, I don't know.
Okay,
But
anyway,
point is,
yeah.
the opt-in part, I think, is the first is going to be the first thing to do. Yeah, if you have a small dispute, right, and if a person has to resolve it, and in certain countries around the world, if the person has to resolve the dispute, it's going to take years. So if I opt into a system where, okay, AI is going to decide this dispute, and it's a relatively small dispute, but I will get it done in days instead of years, and so people will opt into that. That's going to happen, I think, relatively sooner than later. As an opt-in, on small disputes and small areas of law where you don't have to do all kinds of research, and you avoid the rule of law problem if people opt in, because then it's voluntary. So if you opt in, so that's going to be the first place where it's going to happen.
No. Oh, yeah, okay. You have the floor. Please, let me introduce yourself first. And
My name is Fernandes. I go to Hofstra University as well. Invited me. My question is more towards Mr. Zaslowsky and Professor Black as well, who will touch upon this. When it comes to AI, you said there's a possibility that there may be alternate arbitrators, decision makers, but the U.S. system, or at least the law, as far as I understand, there's black letter law and there's also spirit law, whereas AI would look at the black letter law and say, this is how it should be. We have the Supreme Court, we have higher courts saying, this is how it should be interpreted. This is the greater scale, this is how it should be seen based on how society sees it. Now, if we say it like that, and certain systems in the U.S., I'm not sure about abroad, look at the law as a matter of interpretation, a matter of discretion. If we take AI and we have it applied to immigration, for example, things make more sense. Immigration passes to be more favorable sense for certain people entering the country. But if we take it as far as other aspects, then the interpretation does not really apply to society as a whole. So can you actually see AI being the ultimate arbitrator when things will shift as far as what we see now, like what people like, to all of a sudden the scale is shifting?
So, no. You raise good points, and I think I mentioned some of them, right? Empathy is a part of judicial decision making. At least now, my understanding, AI doesn't have empathy, right? I think it's funny though that if anything we're talking about now, and right, it's on the video there, play it back 20 years from now, and what I say today about what AI could do, it's probably going to be laughable. I have no idea. But the issues that you raise are real ones, and that's why I'm saying I think I can see it happening as an opt-in for small cases in congested jurisdictions where the issues are not complicated. I see it being much harder where there are complicated issues of fact, discretion. Then it's going to be harder. But I'm not going to say I can't see that happening because I have no idea. The advances between ChatGPT 3 and 4 are exponential. So you keep going exponentially 5 years from now, 10 years from now, 25 years from now. I don't know. But the issues you raised are real ones. And you're probably somewhere along the way going to have legislation saying whether it's permitted or not. But the technology will probably get there. I think.
But I do think nowadays AI has certain empathy already. Yeah, already.
Well, you know, the guy from Google got fired for saying that he thought his AI was sentient. Right?
Thank you for the question and answering.
You know,
and
the
then,
technology
is there anybody
so
who have the
quickly.
floor to make a question? I see none, so it's time to conclude. And thank you very much for the panelists for your valuable comments. The session is closed. Thank you.